Hi everyone, thank you so much for joining our webinar today. My name's Lauren, I'm one of the senior lawyers in LegalVision's commercial contracts team, and I'm joined today by my colleague Hammy, who I work alongside. We both work with a lot of tech businesses and are very excited to be running this webinar today. So the topic is 5 essential contracts for your tech business. In terms of what we'll be speaking about today, we will, I'll run through that in a minute, but before we begin, I just wanted to flag that at the end of the webinar, we will send you through a copy of the recording. We'll also have a question box that you can submit questions in. At the end of the webinar, we'll run through all your questions, so please feel free to submit them as they pop into your mind, and we'll get to them at the end of the webinar. We'll also be sending through a survey at the end of the webinar, so if you could please fill that in, that would be really helpful. In terms of what we are going to discuss today, we're going to run through the 5 essential contracts for a tech business. So this includes your confidentiality agreement or NDA, your customer facing agreement. So these are the terms and conditions you have with your customers, having a privacy policy, a shareholders agreement, and we'll also run through having agreements in place with your employees and contractors. After that, as I mentioned, we'll run through any questions you all have, and this is always one of the best parts of the webinar, so please feel free to submit those questions. And at the end of the webinar, we'll also have a special offer for everyone that's attended in regards to how LegalVision can help you through our LVConnect Pro membership. So firstly, Hammy's going to run through confidentiality agreements and how you can use them to protect your business.
Thanks, Lauren. So hi everyone. What is a confidentiality agreement and why do you need it? So a confidentiality agreement, also known as an NDA, is a contractual obligation between 2 parties that is designed to protect you when you're sharing commercially sensitive or confidential information. It typically requires the party receiving confidential information to make sure that that information is protected, that they're keeping it safe, and they're not allowing it to be disclosed to the general public. Now, NDAs can be one way, meaning only one party has obligations of keeping that information confidential, or they can also be mutual, in that both parties are receiving confidential information and therefore both parties have obligations on keeping it protected. An NDA allows parties to share information on the understanding that any information they share won't be used to their commercial disadvantage. So it really is designed to protect everyone that's involved. From a disclosure perspective, so if you're the party that's disclosing the confidential information, it gives you peace of mind that your information will be protected. And if something was to go wrong, you have this contract in place so that you can seek a remedy through a court if, for whatever reason, there is a breach of that confidentiality agreement. If you're the person receiving the confidential information, it gives you peace of mind that you're receiving all of the information you need to make a sensible decision about whether this is an appropriate commercial transaction for your business. So it, really is designed to protect everyone that's involved. So we really would recommend you put these in place. Now, in terms of when to put them in place, an NDA is generally used in the early stages of a transaction. So when you're still getting to know each other, you're having a think about whether you want to work together, you haven't quite figured out all of the commercial details of your transaction, have that NDA signed from the very beginning so that all of those discussions are protected. And then once you've decided that you would like to work with this other party, you can enter into a more substantial agreement, as we'll speak about in a moment. That will include confidentiality provisions, but will also cover things like the services that are being provided, the protection of IP, how pricing and payment will work. So it's designed to be a bit more of a holistic document. Having your own NDA means that you can decide the terms on which you're disclosing or receiving confidential information. It allows you to be in a bit more control of that relationship. And it's also really good to have your own template for time-sensitive matters. Because if you suddenly decide in an hour's time you're meeting with a potential investor and you can be sharing some financial information with them, for example, you have a template that's ready to go, and you don't need to reach out to your lawyer in a bit of a panic and say, I'm meeting in an hour, I need an NDA. Your template is ready to go. You simply need to put your investor's name on there and hand it over. Some things to think about and when drafting your NDA and things to include, have a think about how long the agreement should go for. So how long do the confidentiality obligations last if you decide not to proceed with the transaction? What's the purpose of the NDA? So why are you disclosing this information, and what can parties receiving the information do with it? Further from that, who can they disclose that confidential information to? So for example, can they share that information with their employees for the purpose of coming to that informed decision about the confidential information about the transaction, or is it purely just for their ears and eyes only? And then finally, what happens to the confidential information after the transaction is completed or after the agreement is terminated? Do you want them to return all of that information to you, or do you want them to shred it or destroy it? So have a think about, holistically, what happens to that information at the end of the transaction. Now, as I mentioned a little bit earlier, an NDA is not suitable once you've decided to work with a party. It won't cover sort of everything that you need it to do. So I'm going to pass over to Lauren now, who's going to run you through some of the customer-facing agreements that you might want to think about.
Thanks, Hammy. As Hammy mentioned, the confidentiality agreement's just going to cover off confidentiality, but when it's time to get some customers to engage you to supply your services, you're going to want some terms and conditions in place that cover the more broad things. So, for example, making sure you get paid, outlining what the price is and what the payment terms are, setting out what services you're going to be providing. These are things not covered in the NDA, but are sort of crucial for your business. So in terms of customer-facing agreements, these are the terms and conditions you have with your customers. The reasons you'll have them in place is to set out the relationship between yourself and the person buying goods or services from you. It's a great way to protect your liability, mitigate any risk. You can set out things that you don't want to be responsible for in that document. And it's also a good way to make sure both parties are on the same page should any dispute arise. Hopefully not, but hopefully if someone, for example, wants to terminate a contract, you can just look to the termination clause and easily see what the parties had decided. So what I'm going to do now is I'm going to run through a couple of different types of customer agreements that we often see tech businesses use. So the first one is a SaaS agreement. SaaS companies are on the up and up, and there's lots of them going around at the moment. Essentially, it's a model of providing software usually via the cloud. And so it's centrally hosted and then people can access it online. They don't actually have to download some software. Key examples of some popular SaaS products at the moment would be things like Slack, MailChimp, SurveyMonkey, Zoom as well. In terms of providing your, if you're a SaaS business and you're providing a SaaS product, there's a couple of key things you want to think about when providing your T's and C's to a customer. So a key one would be your license. You're giving them permission to use your software, but you want to make sure that you retain ownership of the software. And the beauty of giving your customers a license to use it is that you can put the parameters around that you'd like to. So you can say, for example, well, only 5 users can use the software, or if you want more users, then you need to pay for that, or you can only use it for internal business purposes. You can set out what the restrictions are, which is one of the features of your SaaS agreement. Other important things would be around data ownership. So if your SaaS product can produce any sort of output, so a report, for example, you want to be clear on who owns that. Privacy will also be a key concern for a lot of your customers. If they are putting personal information into your SaaS product, they'll want to know that you're going to look after it. And you'll also want to know that they're only inserting or inputting information that they have a right to input. So if they're putting in information about their customers or someone else, a third party, you'll want that promise from them. And of course, you can use the contract to limit your liability. So you won't want to be responsible if they're relying on the software and it goes down and then they lose some sales, for example. You want to limit yourself in that situation, or if they cause a privacy breach and it's their fault but you get fined for it, you want them to take responsibility for that. So we can use your SaaS agreement to protect you and also to manage the expectations between the parties. The next type of customer-facing agreement I'd like to run through is a managed services agreement. This is typically used when you've got an IT services provider that wants to provide managed services. So they want to provide IT services to a customer, usually on a subscription basis, an ongoing basis, and you basically take control and help with all IT services and perhaps procurement of hardware for your customer. In terms of doing this and taking that control, there are a couple of key things that you'll want to consider. The first is if you're running anything on a subscription basis, you want to be clear on what's included in your services. So we don't want people sort of what we might call scope creep, where your customers are asking for too much for what you've charged for. So your managed IT services agreement should set out clearly what's included and hopefully what's excluded. The other thing that your customers are really going to want is probably some promises around the service availabilities. If their computer goes down, they'll probably want you to fix it within a certain amount of time. This is often achieved through a service level agreement. So you'll have to be careful with these. If you're providing services, you obviously want to limit any promises you're making here. So make sure that they're realistic. Usually what we see is people will set out different sorts of service levels. So if a issue which is quite severe comes up, maybe you'll fix it within 2 hours. But if it's a very run-of-the-mill issue, you might fix it within sort of 5 days, for example. You can also set out what happens if you don't meet these service levels. So perhaps it's just a case that you'll want to use your reasonable endeavours to meet them. Another alternative would be that you provide service credits. So you give your customer a discount off the following month, or perhaps your customer will want to be able to terminate the agreement if you're not meeting those service levels. So in terms of providing managed services, it would be an ideal position to just use your reasonable endeavours there and to not have too many ramifications, I suppose, in terms of meeting any particular timeframes. The last type of customer-facing agreement I want to run through in terms of running a tech business are software development agreements. So a lot of businesses are software developers. You're creating software for clients, you're creating websites, mobile applications, or even software internally for a business. When doing this, generally the most contentious concern is IP. Your customers that are paying you lots of money usually want to own that IP. You'll use your contract to set that out, but we can put in place things to protect you. So for example, that they will only own that once they've paid for all of your services. You'll also want to make sure there's some certainty around time and cost. So if you've promised that it's going to take 6 months, for example, to build something, and then you're constantly delayed because your customer won't give you the information you need, we want to protect you in that instance. And we also want to protect you from any liability issues. So if your customer's giving you lots of IP or source code that's theirs and putting it into, and you're integrating that into their website, and they've stolen that from somewhere and you find yourself in hot water, you want to be protected in that instance. The last thing I want to flag is that in some instances, the Australian consumer law and related sort of laws can apply in B2B situations. So just because you're providing services to another business doesn't mean that you don't have obligations under the Australian consumer law or unfair contract terms. And in New South Wales, you also have an obligation to notify your customers if there's any substantially prejudicial terms in your terms and conditions. So that's just something to think about when you're putting them together to make sure they're not too unfair and that you are not depriving anyone of any rights they're entitled to under the Australian consumer law. In terms of providing your tech business, privacy is a big concern for a lot of your customers. And so Hammy is now going to run through what a privacy policy is and how you should be using one.
All right. So a lot of consumers these days are really concerned about how their data is being handled, where their personal information is going. And that extends not just to consumers, but also to businesses. They want to make sure that the privacy obligations they have to their own customers are being passed on between their relationship with you. So a privacy policy sets out how your business collects holds and uses personal information. Now, personal information in Australia is defined as any information, including an opinion, about an individual that is identified or identifiable. So at a minimum, it includes things like their name, their contact details, their address, their geolocation data, things like that. Now, a privacy policy is a blanket document that is designed to cover your whole business rather than individual products or services that you might offer. So you can have just one privacy policy and make it available on your website for all businesses or all consumers that come across your website. Now, in terms of who is required to have a privacy policy, you'll be required to have a privacy policy if you are an APP entity. An APP entity is a business that has an annual turnover of more than $3 million, or if you have an annual turnover of less than that, if an exception applies. Now, the most common exceptions that we see are that you're a health provider, that you're in the business of buying or selling personal information, you're a contractor and you provide services to the Commonwealth government, you're a credit reporting body, or you are a business that's accredited under the Consumer Data Right. Now, that's not all of the exceptions that apply. There are some others, but they're the most common ones that we see. Even if you are not an APP entity, it is still best practice to have a privacy policy. And that's just because, like I said earlier, a lot of people these days are concerned about how their information is being handled. So we often find that businesses that have a privacy policy are reputationally viewed as more credible. In terms of what to include in your privacy policy, now this is dictated by the privacy legislation, but at a high level, it includes things like, what information you're collecting, how you're collecting it, what purpose you're collecting it for, who you'll be disclosing it to, and if it's being disclosed overseas, where it's going. Your privacy policy should be up to date with your current practices. So it's a working document. If your privacy practices change, your privacy policy should be updated. Now, privacy laws are different across different jurisdictions. So you may have, if you're working across borders or if you're working with clients located outside of Australia, you may have them asking how you comply with the privacy laws in their jurisdiction. So that's just something to have a think about as well. Now, in terms of the customer-facing side of things, we've covered most of the documents that you'll need there. But in addition to that, it's also really important that you have a think about the documents that you'll need internally. So I'm going to hand back over to Lauren, who's going to chat through shareholders agreements and what they are.
Thank you, Hammy. So a shareholders agreement is a document that is between the shareholders of a company. So if you're running a company and there's more than one shareholder, you've founded the company with a co-founder, or perhaps there's a few of you, then you should have a shareholders agreement in place. And what that shareholders agreement does is that it sets out the relationship between the different shareholders in the company. And it's super useful because it will set out how decisions can be made between shareholders and directors. So in a company, you may have appointed directors, perhaps that's yourself, and you'll have more obligations than individual shareholders. You'll be involved in the day-to-day running of the business. Your shareholders agreement will set out things like how directors are appointed, who has a right to appoint directors, which decisions are going to be made between directors, or which decisions need to have shareholder input. And we'll also cover things like what happens if someone wants to sell their shares. So this is quite a common one. You've started a business, there's 2 or 3 of you, it's early days, and then someone decides they want to leave. You probably want the right to buy back those shares so that you can maintain control in the company, as opposed to them just selling their shares to their friend down the road, and now you've got someone part of the company that you weren't expecting. So you can set out some obligations there about how decisions will be made when shares are sold. And you can also cover off things like employees. So if your business is going to offer any sort of shares or options to employees, you can put in place some parameters there. So what's the maximum amount we can offer them, for example, or the maximum amount of the share capital in our business that can be given to employees. There'll also usually be some clauses in there around the removal of directors. So if someone's not pulling their weight or yeah, basically you want to remove them, you'll need to follow what's in the shareholders agreement. Shareholders agreements are very important because, particularly early stage of a business, you've got a couple of you there. It just makes those decision-making scenarios easier so that we can minimize the chance of a dispute. As further and further shareholders come on, particularly if you're raising capital or seeking any sort of investment, then your new shareholders will sign the shareholders agreement and be bound by it as well. And they'll always want to see that to know how they can play a part in your business. The last type of contract that Hammy and I'd like to go through today is the contracts you have with your staff. So your employees or contractors, anyone that you engage to help you out with your services. So Hammy's going to run through that now.
Thanks. So it's really important that you've had some discussions with your lawyer and you're correctly classifying the relationships with your staff. You're very clearly identifying whether they're an employee or a contractor. It doesn't always come down to the agreement that's in place, but rather it comes down to the actual substance of the relationship. So some key things that are considered include how much autonomy or control the staff member has over how and when they work. Are they providing their own tools or are they using yours? Are you providing them with a uniform or can they wear whatever they want? And so a few things that are sort of a very short list of what's considered. There are quite a few considerations that go into this, but once you've appropriately classified whether your staff member is an employee or a contractor, you then need to look at getting the right contracts in place with them. It's important to have agreements in place with your people, as much like your agreements with your customers. They set out the key terms of your relationship. So, for example, you're promising your customers that you will hold their information, confidential information, and protect it. You need to make sure that if you're sharing that information with your employees, they also have the same obligations to you. So whatever you are promising as a business, your employees should be required to support you in fulfilling those obligations and those promises. And that's exactly what your employment agreement or your contractor agreement will set out. Some key things to consider when drafting your employment agreement or your contractor agreement, your IP. So if your employee or your contractor creates something for you, for example, they develop a website, what happens to that IP? Who owns it? Now, you want to make sure that anything that's developed for your business or any work that's done for your business during the course of the employment vests with you. So even if the employee leaves, you can continue using that piece of work that they've developed and continue offering it for the benefit of your clients. Next, as I've sort of already alluded to, confidentiality. You want to make sure that any obligations you have to protect confidential information, that they're being passed on to your employees, and that any customer information they receive, they are keeping confidential. But also beyond that, as an employee, they're very likely to have a lot of information about your business, things that you may not necessarily want getting out into the public domain. So there should be an obligation on your staff member, whether they're an employee or a contractor, to make sure that they're protecting that information and they're not disclosing it when they're not supposed to be. Moving on now to privacy. Again, you've got obligations under, particularly for an APP entity, under the privacy principle, and you can't manage those obligations on your own. You want to make sure that any personal information your employees are coming across in the course of their employment with you, that they are managing that as they're supposed to be under the legislation. Because if they do something wrong, it is going to be you that gets in trouble and not them. Now, particularly if you're looking at engaging contractors rather than employees, you want to have a think about liability and indemnities clauses. If a contractor is performing services on your behalf and something goes wrong, you don't want to be liable for that for those services. You want to make sure that if a customer comes to you and makes a claim of any sort, you can pass that on to your contractor because they're the ones that actually did the work. Now that brings us to the end of the information that we had prepared, and as Lauren said, to the start of the most exciting part of this webinar, Q&A time. So if you've got any questions, oh, sorry, you got ahead of myself a little bit there. At the end of the webinar, you will be able to download our 6-key SaaS contract essentials fact sheet. So if you're running a SaaS business and you want to learn a little bit more about what needs to go into that contract, feel free to download the handout in the handout section in your webinar panel. Q&A time. So if you haven't already done so, please submit any questions that you have through the live chat box, or there's also an email address on the screen if you want to contact us. Lauren, have we got any questions that have come through?
Yes, a couple have come through. One of the first ones, perhaps you can answer. It says, what are some key items to include in an NDA to ensure the other party doesn't copy our product?
Yeah, of course. So we slightly covered this a little bit earlier, but you want to make sure that you're very clearly defining what the confidential information is. So it can be as broad as you need it to be. If you're disclosing a lot of confidential information, it can be sort of, or anything that's shared, whether it's marked as confidential or not. Then you want to make sure that the purpose is very clearly defined. So you want that purpose to be fairly narrow. If you're giving confidential information to another party, the information that they're sharing, you want to control the reasons why that they can share that information. And then, as we spoke about earlier, having to think about some of those more generic things like how long the confidentiality obligations will last, and what happens with the confidential information at the end of at the termination of the agreement.
Okay, thank you, Hammy. We've got another question here saying, how do I set up a contract for clients where we are taking on their digital marketing? So I presume here you mean you're a digital marketing services company. Censor another response if that's not correct. When you are providing digital marketing services, having a contractor in place is certainly a very good idea. You want to set out what services you're providing. Often I'm finding that these are done on a subscription basis or a monthly fee. So what's included in that fee and when is that going to be paid? The other key thing that happens and comes up a lot in digital marketing situations is that whilst you're probably well qualified and do this every day, you don't want to be making any promises around helping the client to meet a certain threshold or generate a certain number of leads or conversions. You can do all you can, but at the end of the day, you can't really control what Google Ads does, for example. Other key things that come up in those arrangements are in relation to having access to your clients' credentials, login credentials for things like Google Ads or their Facebook account. Do you have access to that? When can you use it? Do you need approvals before doing anything? And another big one is expenses. So who is paying for those, for any ads, for example, that are being put up? Is that on top of the monthly fee, or is that included? Is that coming straight out of the client's account? Do you have permission to spend that money on their behalf? So usually we see that there would be a media budget or something along those lines, and that often can be quite flexible because you might you can't really control, I suppose, the prices, but these are things that are we see coming up in these agreements between digital marketers and their clients. Hammy, is there another question you'd like to run through?
Yeah, so there's a question here on how should contracts be signed, i.e. witnessed or two directors? Where or how is this defined? Now, the execution requirements of a document are set out in the Corporations Act, and it depends on how your business is structured. So if you're a sole trader or a partnership, your signing requirements will be different to those of a company. It also depends on whether you're signing an agreement or a deed. Now, an agreement is, the difference between an agreement and a deed is that an agreement comes with consideration, whereas a deed is one party making sort of a one-sided promise. So a deed requires witnesses when it's signed. It requires the signature of a director and a company secretary or two directors. Whereas an agreement doesn't always necessarily need witnesses. If you're a company that's signing an agreement, it could just be, there's a couple of sort of options. It can be two directors, a director or company secretary, or if it's a sole director and sole company secretary, then that one person. So there's a few different requirements there, and if you're looking for a bit more guidance, the Corporations Act would be the place to look.
Thanks, Hammy. There's another question here which says, do I need an employee or contractor agreement for e-learning training? I would like to use another company's training as one of the services I provide. What would I need to include in a contract? So typically, if you're going to use another company's materials, you should definitely have a chat with them first and make sure you're both on the same page. If you just take their materials, then in many situations you would be infringing on their copyright. Usually, if you can come to an agreement that they're allowing you to use their materials, it would be some form of IP license. So they're licensing the content they've created to you. And in that document, you'd set out, well, this is the purpose of the license. This is the reason we're allowed to do it. How long that license goes for. So can you just use it forever, or is it only for a certain amount of time? And how you're paying for that license. So is it a one-off fee and then you can just use it as much as you want? Or is it a per use basis, or an annual fee? You'll need to set out how that works. If someone's actually going to sit down and create content for you, that's probably a little bit different to someone already having content created and they want to retain ownership of that and license it to you. If you're going to engage someone to create the content, you'll probably want to use an employee or contractor agreement depending on the situation, so that you can set out what services you're expecting from them and that they do a good job. You'll also want to set out that you own the IP in those situations. And the benefit of owning the intellectual property in such training materials or content is that then you can do whatever you want with it. The contractor can't use it. You're the only company that has access to that material, and you can, if you sell it or whatever you want to do with it, you've got the sort of upper hand there. So I'd certainly recommend having a contract in place if you're planning to use someone else's materials. It'll just be a case of whether they're just licensing it to you or whether you're engaging them to create the materials for you.
Okay, so are electronic signatures acceptable? Now, we've become a lot more open to electronic signatures, particularly given the whole pandemic thing that's happened over the last couple of years, but it really does come down to what's in your agreement. If you want to execute documents using electronic signatures, you want to make sure that your document has an electronic signatures provision in it that allows you to sign documents using any form of online platform, for example, DocuSign.
And I'll just jump in there and say that there is some legislation in Australia that covers this. So for an electronic signature to be binding in the case of agreements, as Hammy said, you'll need to have ensured that both parties consented to the document being signed electronically, which you can do in the contract. You also need to use a method that can identify who's signing the document. And you need to use a method that's reliable. So that is why a lot of businesses you'll see are using things like DocuSign, because we know they're reliable, and we know that if someone signed it, there's a copy of who signed it, and it's, I suppose, provides a lot more certainty. We've got another question here, which says, we're a website development firm. We would like to get your thoughts on ad hoc work contracts. Currently, we just work on good faith agreement, usually because the amount is relatively small, and we usually have fixed cost project-based contracts with clients in place. Could you please provide some general advice on contracts for ad hoc work hours? So in terms of being a website development firm, we'd always recommend you have a contract in place with your customers for the reasons we sort of previously mentioned, setting out what the IP ownership is, setting out what you're going to provide for the amount that's actually going to be paid. In terms of how you can set these out, there's a couple of different ways. So one of them might be to have what we'd call a framework agreement or an order form agreement. And what this would be is a contract. You set out your software development agreement, and then you ask, you say that every time we do a new project, it will be under a separate statement of work or a separate purchase order. And so each time you do a new project, you can agree on what those fees will be and what the services will be, but those same terms and conditions will apply. And that makes it a lot easier for these ongoing arrangements, because it means that you don't need to get a new contract signed each time. You can just agree on the commercials, and you know that that other contract will apply to that situation. In terms, so that's probably what I'd recommend in terms of, an ongoing relationship with lots of different projects. Alternatively, if you're doing work on an hourly rate, I suppose that doesn't matter as much, because each time you do the work, you'll just bill for that. There's another question here about founders and shareholders agreements. So it's when you start up a business with a founder, a co-founder, you should definitely have a shareholders agreement in place. If anything else is sort of decided between the founders, particularly in regards to their duties, then that can be set out in employment agreements or other documents. In terms of IP, if IP was created before the company was incorporated, which often happens if you've come up with a good idea and you've just created it, you'll want the founders to assign that IP to the company so that the company owns that IP, not the founder. This is super important for down the track. For example, if you've got investors that want to come on board, they're not going to want to invest in a company that doesn't own its IP, because if someone just prevents access to that or walks away, then that they won't be impressed. So often we'll see those founder IP assignment agreements put in place.
Okay, I think that's the end of our questions. So if there's no other questions, we might move along. So as Lauren said earlier on, we have a special offer for anyone that's listening in on this webinar. You're eligible to receive a complimentary consultation to discuss how our LVConnect Pro membership can help your business. And at the end of that complimentary consultation, there'll be a special offer for you to redeem. Now, if you're not satisfied with your membership, you can cancel in the first 30 days, no questions asked. But I guess I should probably tell you what the LVConnect Pro membership is. It's designed to provide holistic support for your business and sort of be your one-stop shop for all of your legal needs, kind of like having a lawyer work in-house for you, but at a fraction of the cost. So the LVConnect Pro membership gives you a very wide range of benefits, including unlimited document drafting and reviews, unlimited legal advice consultations, employment law support, things like that. So really everything that you will come across from a legal perspective in your day-to-day business as usual legal needs, they will be covered off and looked after under this agreement. And then if there's anything that's not included in the membership, we give you some very significant discounts on that as well. You can book in for your strategy session and to redeem your offer via the survey that's going to appear on your screen after the webinar. Just click yes and leave your contact details, and someone from the team will be in touch. All right, that's it from us today. Thank you so much for joining. We hope you've all learned something. We've had a blast, and we look forward to seeing you next time.
Thank you.